Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3094, United States of America versus Lamont Johnson, also known as Black Appellants. Mr. LaCar for the appellant, Ms. Kelly for the appellate.
Good morning, counsel. Mr. LaCar, please proceed when you're ready.
Thank you. Good to see you all. As the court is aware from our briefs, this is not a routine sentencing case. It's a de facto life sentencing based on constitutionally unreliable information. In the limited time I have, I hope you'll indulge me perhaps a minute to 90 seconds to give you my three core theories, if that's possible. The first issue I want to talk about is the relevant conduct. The government doesn't really seek to justify the district judge's finding that my client had engaged in multiple discussions of multi-gallon purchases of PCP. That's simply unfounded. We have put all the relevant text in the evidence. There were no cooperators who testified in the appendix. No cooperator testified at the trial. No cooperator testified at the sentencing, even though those cooperators are clearly under the government's control. What the government has done here is switch courses. They want you to become a court of first view, not a court of review. They want you to decipher near incomprehensible coded conversations and try to figure out what happened several years ago. They, in effect, want you to reward them for not calling any of the cooperators at the trial or at the sentencing. And I don't think the court should do that. They also want the court to consider proffers, what the law declares as notoriously unreliable proffers, inculpatory statements of co-defendants that were not presented below the district judge. Now, we've rejected that. That's just not, that's not fair. That's something that should have been explored below. If they didn't want to call the cooperators, I can understand that, but that's the responsibility of the government. It's their burden to establish relevant conduct. And our position is, quite simply, this is a Stover case. This is a case of United States versus Daniel Stover that we cited in our brief. Second, and it should be remanded for proper fact finding. The role in the offense, that's a simple one. This case does not meet any of the criteria that the courts typically rely on, that the courts of appeals typically look to decide what somebody's role is in the offense. Now, in this case, if you look at the government's pre-sentencing memorandum, they depict Mr. Johnson as the drug supplier for the entire Jahi Marshall drug trafficking organization. That's what they put, and it's in the record in their sentencing memorandum. Now, if Mr. Johnson was a supplier for the entire network, how could it have thrived when he was unambiguously bereft of drugs, unable to pay the rent, unable to meet his car notes? It doesn't make sense. He didn't recruit anybody. He never met Jahi Marshall. He wasn't on the scene. He didn't share profits. At the best, their argument then shifts to, well, maybe he controlled his co-venture. But the law is you don't control your co-venture.
So I do have a question or two about this part of the case, the manager supervisor one, but can we go back to the drug quantity for where you started? So I take it you don't disagree with what the government says at page 49 of its brief in terms of the quantities. In other words, if it's true that there was a gallon involved and then 8 ounces and then 16 apiece, that amounts to over 3 kilograms. The question...
I do disagree.
No, I'm just talking about the math.
Well, I want to talk about the math because that's a valid question. I'm glad you.
So I guess I'm surprised that you disagree with that. Well, what I took to be the principal submission is that there's just not evidence that supports the amounts. Not that the amounts don't translate into 3 kilograms. And maybe I'm wrong about that. But on whether the evidence supports the amounts, and it seems like the big question is the 1 gallon, is whether there was in fact 1 gallon that came from the West Coast.
3 gallons to get to level 32. You have to have 3 gallons or more, either pure PCP. I'm sorry, 3 gallons of a mixture containing PCP. They don't have that.
Why do you say 3 gallons? In the expert testimony, 22 grams per fluid ounce?
Here's the problem. The expert, that's his testimony, but here's where he misses it. First of all, let me give them the gimme. What they seized from Mr. Johnson's car, that's 1.45 kilograms. That's about essentially 90 ounces if you do the mathematics. And I've done a calculation table last night. If you gave them the 40 ounces, which the evidence doesn't support, if you gave them, there's a mixture of 40 ounces of PCP, you still come out under what you need for 3 kilograms or more of a mixture. So the math doesn't add up. This is another reason.
I want to answer though to the question of, do you think that it's clear error for the district court if the district court relied on 22 grams per fluid ounce, that was clear error, and if so, why?
Well, first of all, that backs into the standard review. Do I think it's clear error? Absolutely. But I also think you should give the entire methodology a fresh look, as the majority of circuit courts of appeal do. This circuit has never directly ruled on methodology. And I've urged in my opening brief and my reply, there should be a de novo standard review. And the fact of the matter is, the judge's findings, when you read the sentencing transcript, they just don't make sense. The way he approached it, there was some confusion in the record.
Tell me why 22 grams per fluid ounce, even if we review this de novo, shouldn't be used. I mean, where was that contested below?
Which grams you on?
22 grams per fluid ounce. We got to convert from liquid in ounce, gallon measurements to grams and kilograms for the purpose of the sentencing table.
I believe in the sentencing memorandum below, he did contest the method. He did contest the amount. And if you calculate, if you look at a mixture, if you take a mixture of PCP, because that's what they got, wasn't pure PCP. If you have 1.45 kilograms, that computes out essentially to just about 50 ounces. 50. If you gave them 40 ounces, it still wouldn't get them to where they're looking.
How are you doing that conversion? What unit of conversion?
What ratio?
I did a kilogram to ounces conversion, Your Honor.
Kilogram to ounces by fluid ounces or by weight? See, the problem is that a gallon is 128 ounces, but that's fluid ounces.
Right. That's what I did.
So that is not the same as how many ounces in weight a gallon of milk or a gallon of water or a gallon of PCP weighs.
The problem is it's a mixture. It's not pure PCP. There are two alternatives. If you have 300 grams of pure PCP, that gets you to level 32. If you have a mixture, you have to have 3 gallons or more of a mixture to get you to level 32. As the Barrows case that we cite in our brief says, caution has to be taken when you're looking at quantity. And what the district judge's core finding was that they shifted on. His core finding was that there were multiple discussions of multi-gallons of PCP.
Well, your brief at page 4, opening brief, says, because based on the intercepted conversations, that he was seeking a gallon. Your brief acknowledges that.
I think that's right, but there were multiple conversations concerning multiple gallons.
So I guess if he was seeking a gallon and the record supports that he got a gallon in the beginning of October, and then there were a couple prior sales of 8 ounces, 16 ounces, if you add that gallon to those prior sales and use the 22 grams per fluid ounce conversion, then you're over 3 kilograms.
Here's the problem about argument. There's no evidence of prior sales.
Wait, hold on. Am I misreading doesn't the expert testimony in this case, which I think is undisputed, it says that a gallon plus 16 ounces is more than 3 kilograms. Am I reading that wrong?
I'm sorry, I'm having difficulty.
The undisputed expert testimony in the case. You said there was nothing in the record that supported it. But the undisputed expert testimony in the case says that a gallon plus 16 ounces is more than 3 kilograms.
What?
Am I reading that wrong?
No, you're not, Your Honor. That may be undisputed expert testimony, but that's based on the assumption that all of the transactions were sales. They're at the key issue here.
No, but you in response to Judge Wilkins, you admitted, and you said in your brief that the wiretaps show at least 1 gallon, show a gallon, and later the wiretaps also show the 16 ounces. And those are both in your brief. You can see the wiretaps show both of them.
No.
And then you have an expert who says those two add up to more than 3 kilograms.
No, there's a mistake here. What I'm saying is...
Wait, where's the misstatement?
The mistake is the expert's testimony is based on the assumption that there were prior sales in late July 26th to 28th. There were coded discussions that nobody can decipher. You can't figure out what happened here. The people who engaged in those coded discussions, specifically Kavron and Jamar Gage, were never called by the government to testify. Nobody testified to that, although the experts assumed that those were
There's
sales.
evidence about what the coded discussions meant. You know, maybe that testimony was reliable, maybe it wasn't, it came in. And the jury must have found it credible because they convicted your client, and you're not making a sufficiency or any other argument challenging the conviction. So if the coded discussions were sufficient to justify a conviction, why aren't they sufficient to justify a sentence?
Because of all due respect, Judge Wilkins, you're looking at the wrong end of the telescope. Again, the 1.4 kilograms the 1.4 kilograms that were seized in October, that's a gimme. The jury finding was 1 kilogram or more. There was a discussion below in the record, should we have specific jury findings as to the quantity? The government decided not to go with that. They went with 1 kilogram or more. So of course the jury found 1 kilogram or more. Let's be realistic. That was what was seized. The question, what this case turns on, is the difference between what was seized and those amorphous conversations that the district judge's findings just don't address. His findings are, quote, there were multiple discussions throughout the case, multi-gallon deals. There is no such discussion. I have spread every single one of those texts in the record. Nobody testified to support that. It was the expert his testimony is based on his own assumption. It was his assumption.
His testimony is based on conversations where he's saying Slim or Shorty's going to get me a hole, or I'm going to get a hole this time. And then testimony that usually comes in a gallon, sometimes in a half gallon. And the inference being that if he's saying a hole, then he's referring to a gallon.
Mm-hmm.
Why is that unreliable for the purpose of making a sentencing?
As I've said, the district judge didn't make a correct finding here. These are coded discussions that the actual participants, the people who were best situated to know what happened, were not called by the government.
So there might be, maybe it's true that there could be better evidence, but the question that we're reviewing is whether it was clear error to find that the 3 kilogram threshold was found. And as I read the government's brief, the 3 kilograms, the biggest amount that gets you to 3 kilograms is the 1 gallon PCP shipment from the West Coast. That's the bulk of it. That's 2,700, but per the government's calculation on page 49 of its brief. Can I just finish?
Right.
Per the government's calculation on page 49 of its brief. So if it's not clear error to think that there's a gallon, according to the government's calculation, that gets you to 2,700. That's pretty close to 3 kilograms. Now, I'm going to assume, you can contest it, but I'm going to assume that the 22 ounce ratio is okay. I'm just going to assume it for purposes of this question. Let's just assume that that's okay. I guess the question then becomes, is there actually enough evidence that there was 1 gallon? Because that gets you pretty close on a 22, on the 22 ratio. the 22-gram ratio. And on the question of whether there is in fact 1 gallon, there's enough evidence of the 1 gallon. I guess my question is, as Judge Wilkins said, there's the reference to a whole one that was stated by Johnson. And then there's the testimony from the government's expert at page 590 of the joint appendix that says typically at least a gallon is shipped from the West Coast. So why don't the combination of those at least suffice to show that it wasn't clear error to think that there's a 1 gallon amount from the West Coast? And if there's a 1 gallon amount from the West Coast, then per the 22-gram ratio, which I'm assuming is okay, that gets you pretty close in and of itself to 3 kilograms.
It's pretty close, but it's close. It's like horseshoes and hand grenades. You've got to be right on. It's not quite there.
Okay, so then let's, you may think that there's not enough other stuff, and maybe we can talk about that. But I just want to know what's wrong with that to get you to 2,700. Assuming that the math, the 22-gram ratio is okay, what's wrong with that construction of why there's in fact a gallon?
I think what's wrong with it is that there's no testimony for anything. There's no real testimony other than a casual reference and what sees isn't enough.
No, but there's not just that, because there's the reference to a whole one at Johnson. That's in the record. And then there's the testimony from the government's expert that from the West Coast, typically at least a gallon. And the testimony, as I recall, was to the effect of, no one's going to bother to get something from the West Coast unless it's a pretty good quantity. So typically it's at least a gallon. So you get that plus the whole one, and that gets you to a gallon, which gets you to 2,700, which gets you to pretty close. Then there may be debate about whether you can get past the 3 kilograms, but I just want to know what's wrong with getting us pretty close.
I think what's wrong with it is that there's no the actual participants weren't called. The people who knew, who were in a position to know what happened, theoretically, we assume we're not called to testimony. This court is sitting here trying to guess what happened and is there a discussion of a whole one? Yes, I'll grant you that.
And do you think a whole one means a whole gallon?
But no, I'm not saying that's a whole gallon. For all I know, it's a mixture of something. But I know what the expert testified.
Yeah.
The problem is that what the government is, again, asking you to do is to make the decision that should have been made below by the district court. And the district court's view was mistaken. But there were multiple discussions throughout the whole case of multiple gallons of PCT.
So your argument is that the finding that was made by the district court was that there were multiple discussions of gallons, and there's no evidence for that, and we can't reconstruct the finding on appeal to one that comports with, a defensible view of the evidence.
No.
You have to vacate the sentence and send it back.
Not only is that my argument, but I'll go you one better. Who caused that problem? It was caused by the government. It was their sentencing memorandum and their position at the sentencing that he was the supplier for this whole network. That's just physically impossible. There was a guy referenced in the record to a guy who was a supplier named Eric Scott in the spring. My client happened to be picked up at the very tail end of a 2.5, 3-year investigation. And what happened was they overheard him on a wiretap, and they had what the law recognizes as confirmation bias. He's showing up late. He's the guy who must be the main supplier. But he wasn't. There's no evidence of that. What happens here is, essentially, surmise and conjecture as to what the relevant conduct is. And it is a departure.
Let me ask you a question about the enhancement for supervisor or manager.
Sure.
With respect to Ms. Johnson, if there's evidence that she didn't really want to be involved with drugs at all, but he compelled her to do so by calling her, badgering her, etc., why isn't that control? I mean, control is getting someone to do something that they don't want to do. You're controlling.
Well, first of all, if it were Ms. Johnson alone, it would be a 2-point enhancement, not a 3-point enhancement, because he clearly had nothing to do with the Marshall ring. He's not their supplier. He's an independent trader. But with respect to Ms. Johnson...
And why is it only a 2-point enhancement?
Because she's the only person he's dealing with. You have to look at a hierarchy.
But aren't there 5 people or more total that are involved in the conspiracy?
Under Graham and under Weaver, it's a Seventh Circuit case that I submit is actually elegantly written. Under those two cases, what one looks to is there a hierarchy? The only hierarchy in that case would be he and Mrs. Johnson, but there is no hierarchy of he and Mrs. Johnson. It was a one-off episode. She was perfectly happy to get that gun out of a house. Let's be realistic, and get that cooking stuff out of a house. But there's no evidence in the record that she was a participant in that. And I suggest the Mankiewicz case out of the Seventh Circuit, we discussed in our opening brief. In Mankiewicz, the son ran a large marijuana operation. He asked his father, would you put some of the bales on the other side of the barn? And the father said, yeah, sure. Okay, I'll be happy to do that. That's not a managerial.
Was anything found in the premises of Mrs. Johnson as far as drugs?
Boy, that's a good, I don't remember. Just perhaps it's, I'm certainly being the inventory or in the trial transcript. I'd be happy to submit something. But the search warrant that was executed was not at the residence that she lived. Yes,
Is that what you're saying?
I think it was.
Well, that's kind of my point, is that the wiretaps appear to show that she didn't want to be associated with any of this.
And that's why.
And yet the stuff is found at her house.
Well,
That would imply that it was put there kind of against her will.
she didn't want it.
And that would imply control.
No, what control requires is more than a one-off situation. And that's the Weaver case. What control requires is a sort of a continuous situation where one has economic coercion over somebody else. There's no showing that she's a participant getting money for this. There's no showing that she's doing anything to facilitate the offense. The fact that her husband may have used the house to store PCP, which we know PCP dealers tend to do, that doesn't make her a participant. Judge Hogan did not put an enhancement in there for running a crack house. I'm sorry, for a PCP house. That's an important fact. He recognized the house wasn't being used for anything other than perhaps storage. And that's done by him, not by Karen Johnson. She's not a participant because what the law of participation requires is that more, as I said, than a one-off episode. It requires acquiescence, it requires dealing over time and furthering the offense. She's his wife. She wasn't happy about this, but that doesn't make her a participant.
Make sure my colleagues don't have additional questions at this time. We will give you some time for rebuttal.
One last question. Whose name was on the lease of that?
I'm sorry, Your Honor?
What's the evidence about whose name was on the lease of that?
In the lease, probably, I don't want to guess, I would assume both. I'm a little leery about making an assumption. It's a rather shabby apartment that depicts it. Probably that of a big scale drug dealer.
Thank you, counsel. Ms. Kelly.
Good morning, Your Honors. May it please the court. Catherine Kelly on behalf of the United States. Your Honors, in this case, the district court properly found by a preponderance of the evidence that there was indeed support for a level 32 drug quantity, that Mr. Johnson was indeed a manager or supervisor and thus was entitled to the subject to the enhancement, and that the credible threats enhancement properly applied in this case.
So can we start with the drug quantity? So the way that you presented the argument in your brief, the part that gets you the closest to 3 kilograms is the gallon.
That gets you 2,750 grams. So
right. So that gets you that's the bulk of it.
Correct.
In other words, you're not going to get there but for that.
That's right.
Okay. So on the gallon, what is there in the record that supports the gallon and that marries with the way the district court, this kind of top line that the district court articulated in support of this 3 kilogram threshold? Because what I see is one quote that said, I had a whole one there this time. And then that alone, there's no testimony about that I could find about what a whole one means. A whole one what?
Your Honor, it was the government's position that a whole one was a gallon because of the expert's testimony, which was that if you're going to go to the expense of $32,000 to $36,000 a gallon to ship it from the West Coast, that you were indeed going to get a large amount. And
So
his experience.
I didn't even see anywhere, but you can definitely correct me. I didn't see anywhere where the government actually said that a whole one means a whole gallon.
It's
Maybe
my
that's true.
understanding that throughout the case, the government's position was that a whole was indeed a gallon.
But I mean, it might be the position in somebody's own mind, but I'm just looking for something. And was that ever articulated anywhere that a whole one means one gallon?
I don't believe that there was testimony that a whole was a gallon.
And was it in a sentencing memo? Because I don't think I saw it in the government's sentencing memo either.
The government referred to 1 gallon, but I don't recall any statement in the government sentencing memo that a whole is equivalent to a gallon.
So where are we getting this argument that the government's position has always been that a whole one is a gallon? Because the government never said that out of their mouth in the district court.
Or on the
I'm
page.
trying to recall the closing argument, Your Honor. And I'm sorry, I don't have a site right at my fingertips, but the arguments that the government was making definitely were that he was getting, based on the expert's testimony, that he's getting at least a gallon from the West Coast, because that's in line with what.
Well, so one thing that I thought was interesting is that the brief doesn't say at least a gallon. It says 1 gallon. So I mean, I think
the expert said that in his experience that the suppliers or the people who were drug dealers in DC, when they ordered from the West Coast, they would get at least a gallon, sometimes more, but that in his experience, it was mainly that he had seen 1 gallon.
Right. And so then the government's theory was that Johnson got 1 gallon.
Right.
Not that he
During
got
this
8
time
gallons.
between July, that he ordered, I believe it was around the end of August. And our main support for that is the call that he had with Mr. Prelo on the 22nd of August, 2017. And that's cited at Joint Appendix 664 through 670.
Right. That's the statement. I had a whole one on there this time.
That's right. And I shouldn't say that it was our position that he only received that 1 gallon. So to the extent that I may have indicated that earlier, that's not correct, because there were additional statements in there in that same call indicating that he had done this 3 times previously. This is a call, if Your Honor will recall, that he has first realized that day, August 22nd, that the money he has given to the suppliers from the West Coast, he was expecting that supplier to come visit him, and then he got on social media and realized after the supplier failed to visit him that they had in fact gone back to the West Coast without delivering the drugs at that time.
Right. But in your brief, that you did the prior stuff is in a footnote, in footnote 26 on page 49, as I see it. And so what you're really relying on in principal force is the 1 gallon.
For the 1 gallon, we're saying the whole on page 664, and then on page 668 of that same conversation, Mr. Johnson is going on to say that I ran a certain amount 3 times, and then saying
That's in a footnote. That's in a footnote in your brief.
Yeah.
And on the whole one, if there's nothing that the government ever said, might have thought it, but the government said on the written page or an argument that a whole one means 1 gallon, then how do we reach the conclusion that the shipment was in fact a gallon?
Well, we did say at the sentencing, Your Honor, and of course, I would like to point out to the prosecutor told the court at the sentencing it was prepared to discuss the actual drug quantities. The court did not take the prosecutor up on that. But at the end of the sentencing, when they were talking about the government's position that Mr. Johnson should get a 405-month sentence, the government did note Mr. Johnson's acquisition of a gallon of PCP. That's at page 159 of the government's supplemental appendix. And then also mentioned drug expert Cardinal's trial testimony saying that when you receive a gallon, that you would take that gallon of PCP in order to make back any profit after paying, up to $36,000 to ship it from the West Coast. A dealer who was supplying others would then cut that to make it 2 gallons, which is supported by the expert's testimony. So in that sense, we did talk about the acquisition of a gallon. We didn't at that point say a whole equals a gallon, but it's quite clear that we're talking about that gallon that's being discussed.
Right, but I think there was arguments that at least a gallon was and maybe just 1 gallon was received. What I didn't see anywhere is something that tied the comment, the statement, the whole one, to 1 gallon. I didn't see anywhere that the government said what is meant by the statement, a whole one, is 1 gallon.
I don't recall a statement as specific as Your Honor said, but I would just point out that at the sentencing, we were talking about the acquisition of a gallon. And we had put in the testimony at trial of the August 22nd call.
So help me understand something. The draft pre-sentence report is submitted to the parties, and it says that Mr. Johnson is responsible for over 3 kilograms PCP. There's a written objection that's filed to that. That says, no, the jury only made findings that would support over 1 kilogram. And the government's opposition, as I read it, didn't explain any more than the draft pre-sentence report as to how we got to the 3 kilograms. Am I missing something?
I don't recall anything specific in the government's sentencing memorandum that went through that calculation in regard to the 1 gallon. I recall there being additional, we made a more general reference to wiretap supporting that a gallon was delivered, if I'm wrong. And then went into discussions about the 32-ounce sale in July 2017 and then the additional arrangements for at least 8 ounces PCP to be delivered.
So basically the government's theory below was that if the district court were to find that he got a gallon and that would have been around shortly before the arrest, right?
Correct, yes.
And then there was a prior sale of 16 ounces or even that would be sufficient in and of itself to get you over the 3 kilograms.
That would be, yes.
Plus
Your Honor.
16, but the government would say there were a couple more transactions that were supportable by the wiretaps, 16 and an 8, whatever.
Correct. We were saying that there was a 32-ounce sale in July, 16 each to Mr. Gage and then to Mr. Tabron, and then an additional arrangement where Mr. Johnson was selling an additional 8 ounces to Mr. Tabron.
But your expert also testified that it's not necessarily that you always get a gallon. You could get a half gallon.
He said that was possible.
And from the wiretaps, it appears that Mr. Johnson was searched and arrested within maybe 2 days of getting the shipment.
I believe it was 4 days. The drugs came on the 9th, and he was arrested on the night of the 13th. And there were additionally 2 situations in between there where he's meeting with Mr. Freylau, and he's also arranging to meet somebody who was not identified, who said that they were by the shrimp boat, and he was clearly in those calls going to bring drugs. So
And what he's got is less than a half gallon when the search is executed, right?
I'm sorry, Your Honor, I haven't done the conversion to what 1,429 grams would be back into gallons. But there were 1,429 grams of PCP found in the 36 bottles in his.
And that had been diluted down, right?
It was 12% purity, I think. I don't know what purity level he got it at, for instance, but there's certainly evidence that he was.
Well, what's the
diluting
evidence about what purity level you would get from the West Coast in your gallon?
I don't recall there being testimony about the purity level of what we'd normally received from the West Coast. But certainly there was evidence that Mr. Johnson did cut the PCP because there was starter fluid bottles found in the apartment.
Well, that's my point, is let's suppose he got a gallon and he cut it so that he would have 2 gallons.
Mm-hmm.
And then he could sell that. So how is it that he gets a gallon on the 9th, he cuts it to make it 2 gallons or some greater quantity of a gallon? And you got evidence of maybe a couple different sales, but yet they only find about a half gallon at his house if he started out with a gallon.
I don't recall there being any evidence in the record of him specifically cutting this shipment PCP. So I don't know.
Well,
that
let's suppose he did.
he did. Suppose he didn't.
Then he sold a half gallon between the 9th and the 12th, according to your theory.
Which is possible.
Where did it go when your evidence is 2 transactions of not nearly that amount? Right?
Well, the evidence is a call with Mr. Prelo on the 11th, which is at Joint Appendix 744, and a call with an unclarified person, which is Supplemental Appendix 88 through 91, where he's appears to be making a sale. But the point is, Your Honor, is the question is that you just needed at least 3 kilograms of a mixture in substance that contained PCP. So whether or not it's been cut or not, during that time, you still have, given the calculations at page 49 of our brief, we still had over 3 gallons
I understand that.
or over 3 kilos.
But my point is that even if it's never been cut and he gets a gallon on or about October the 9th, on the 12th, he's got about a half gallon.
Your Honor's calculation.
So, well, if 2,700 grams, according
Yes,
to you,
yes.
is if a gallon
Yes, Your Honor.
translates into 2,700 grams, and he's got about 1,400 or so grams, that's about a half gallon.
Yes, sir.
So even if nothing was cut, then that means something happened to it in those 3 days between him acquiring it and the search warrant being executed. And I guess all I'm saying is that how does that line up with the evidence of what he was doing in those 3 days? And it doesn't seem to line up.
So we would say that it does line up because of the calls that I mentioned before with Mr. Prelo, and then the additional person saying that they were going to meet.
And the discussions of those, I thought that the discussions, at least with Mr. what's his name, Prelo, were a pretty small quantity, and he's arrested with something like 16 ounces, right?
Several days later, he was arrested with, I think it was.
In other words, those discussions that you're relying on don't get you to the entire rest of the half gallon. They get you.
They don't mention specific quantities that would get.
There's no reason to think that it encompasses, there's no affirmative reason to think that those discussions encompass, let's just stay with the math, that encompasses the entire rest of the half gallon, or even something close to it, because we're talking about what was ultimately found as pretty small ounce quantities.
It's not entirely clear what amounts were passed over at that time, but it's also, though, I think it's very important to note too that you're talking about what is he responsible for. It doesn't mean that if you're found with half a gallon in the end, that means that's all that you arranged for.
Because if he got, I mean, I think it's true that if he got the full gallon and the 22 ratio works, that gets you pretty close. Then the question becomes, is there enough evidence to support that, in fact, the full gallon came from the West Coast to him?
And we believe there is, given the calls and given the amount that was found on him at that time. And indeed, as Your Honors have pointed out, the additional drugs that were found on Mr. Prelo, which we had, obviously, point would have been that was from the gallon. But again, we're dealing with a preponderance of the evidence standard here, which the court used and the government used and met. And additionally, we have, in this case, a situation where my recollection was
we've got to review a finding. And the finding is that there were multiple discussions of gallon, right? That's the finding that the district court made.
That's what the district court said, Your Honor. But I think that the true point here is not the number of discussions that was had. The question is what was discussed. And here it is, the call on August 22nd shows a whole, which the government had interpreted as a And that's based on the expert's testimony.
But nobody made that argument at the sentencing.
Well, we said at the sentencing that Johnson had acquired a gallon PCP.
But you didn't say because he said that he was getting a whole.
We did not say that specifically.
I mean, how are we supposed to know what this, I mean, we're a court of review. How are we supposed to know what the district court actually found, where PSR doesn't articulate a theory as to why there's 3 kilograms or more? The government's theory doesn't appear that it articulated an argument or in a sentencing memo doesn't appear to match up with what the district court found. So how are we supposed to review that?
There was additional evidence in the PSR, Your Honor, which the court adopted in its statement of reasons afterwards, talking about the phone calls on the 26th through the 28th of July that supported the additional 40 ounces. And then there was discussion of the wiretaps supporting the larger amounts. And I will say that it did not specify an amount in that situation, but we did lay out at sentencing as best we could, since the court did not take us to explain each of the actual drug quantities that we were prepared to explain. But the evidence that we've stated here today about prior transactions, the whole, and then the receipt of the drugs in October, plus the transactions.
You're kind of making it seem like this is the district judge's fault because he wouldn't let you argue what you wanted to argue. But that's why you file a sentencing memo, to put in the record what needs to be put in the record and make the argument. So maybe I'm sensitive because I'm a former district judge. But you seem to be throwing the district judge under the bus. This was something that was within the prosecutor's control.
I certainly don't mean to throw the district. Apologize, I've made it sound like that. But given, we would just say that the evidence that was at trial, the court's statements at the sentencing itself, he mentioned knowing of gallons and other quantities of PCP, which would be an apparent reference to the July sales and at least the amount that came at the end in mid-October, that there was a sufficient finding, particularly by preponderance of the evidence. The evidence is certainly in the record. And if I may just
Can I just ask you just succinctly just address this? Suppose, let's just assume arguendo, you'll resist it, but let's just assume arguendo that the reference to a whole one means nothing because there's nothing that ties a whole one to some quantity. It could be a whole gram. It could be a whole ounce. Let's just assume that away. Mm-hmm. If we assume that away, then how do we sustain the 3 kilograms that's predicated on a gallon?
It would really be on the expert's testimony that when somebody is being supplied PCP from the West Coast, which is clear from the calls, that in the expert's experience, that a gallon was the most common amount.
And is that the government's position that even if you totally discount the whole one because there was never a link made to what a whole one means, that we affirm a district court's finding of 3 kilograms that's, as the district court described it, based on testimony, and I can't remember exactly how the district court articulated it, but that what we do is we sustain it based on the government's expert's testimony that it's typically at least a gallon, but sometimes a half.
Yeah, and I would say that the reference to half gallon was a very minor one, but where the expert was saying also that sometimes he's seen, 2 gallons as well. So, but in his experience, his most common experience in this area,
Okay.
that you would get a gallon.
Okay. Thank you.
Thank you. If I just may make one brief point about control of Ms. Johnson, just the defense counsel has said that this was a one-off episode, and I just wanted to make clear that this was not. We mentioned a September 11th text that Mr. Johnson sent to Mrs. Johnson, saying that he needed to get into the apartment because he needed to make some hits.
So I do have a couple of questions about that. So it's a husband and wife who are talking.
They were estranged at the time.
I get that. Yeah. But still, I mean, they are husband and wife, and just it's typically in these kinds of situations where you have a manager-supervisor relationship, there's something more than this. I mean, this is the kind of discourse that often happens among people who share a house. It doesn't strike me as obvious that somebody's managing somebody else with whom they share a place, and especially if they're in a spousal relationship. And yes, they're estranged, and so you can say, well, they didn't really share this space, but they have some joint dominion and control over it. And it just struck me that the kinds of conversations that are going on are typically the kinds of conversations that occur among spouses. I need you to do this for me. I need you to make sure my dinner's warm by the time I get home. It's just, nobody would say that somebody's managing their spouse. That's just the way that spouses talk to each other.
Well, the way the evidence came in, first of all, Your Honor, I want to make clear that they were not only estranged, but they were not living together. Only Mrs. Johnson was in that apartment. And on several occasions, including September 11th, and I believe it was October 9th, he was saying, you need to let me in. So this isn't even a situation where he apparently has a key to the apartment. He can't even go there on his own.
Mm-hmm.
And it's not just a please warm up my dinner kind of conversation. These are texts and wiretap calls where he's ordering her to bring him his cooler, his bottles, his funnels. He's insisting that she let him come over to the apartment that night, which was, I believe, on the 11th. And that
is that not how estranged partners or spouses talk to each other? It just seemed typical of the way people might interact without having a managerial supervisory relationship.
The reason he's making these insistences is that he needs to get to his drug paraphernalia. He needs to get his bottles. He needs to get his cooler so you won't be able to smell the PCP when he's transiting it. And it's clear that all his conversations in telling her what to do are related to the drug transactions and his desire to get these items out on the street. And it's not a matter of just insisting certain things. They're saying, you've got to bring my gun downstairs. You got to, get the cooler into the back of my Cadillac and so forth. And she clearly acceded to this, even though it didn't seem like she wanted to in times, but which again just shows that he is controlling her. And it was neither a one-off experience, nor was it a situation where this is just a normal situation between husband and wife, just talking whether they're estranged or not. They're specifically, he's ordering her around in regard to his drug trade. And
What
for
of
that
the
reason, I believe the manager.
I'm sorry. What of the argument that even if we were to accept that, it's at most a 2-point enhancement instead?
But it applies for the 3-point enhancement because all you have to do is manage or supervise one person who is criminally responsible for the offense and a criminal activity that included 5 or more people. So it meets all the requirements for a subsection B enhancement for 3 levels. Certainly, if there was some reason to in this case, it would be possible to apply the level 2 enhancement under subsection C. But given that the government showed by preponderance of the evidence and the court accepted it on that standard, there's no reason to disturb the court's findings. And I would just note one final point is that there is case law, including the Clark decision, that indicates that just because you're somebody's relative, you can still be in that manager supervisor position. So we would respectfully request that the court affirm the judgment of the district. Thank you.
Thank you, counsel. Mr. LaCar, we'll give you 2 minutes for rebuttal.
Let's see if I can get it down to 1 minute.
Good.
35 years of a man's life, a de facto life sentence hangs on Delphic discussions and unfounded findings by the district judge. And I noticed that we've had 3 Circuit Court of Appeals judges of the second most powerful circuit in this country sitting here for 40 minutes trying to interpret a muddy record. That's not the role of this court. This case should be remanded on all reasons, but certainly as to the relevant conduct. Government counsel couldn't say, and to her credit, she strove mightily, she couldn't say, she said it's not entirely clear, it's not specific. The findings on the relevant conduct were driven by the government over trying the case and by the government sentencing memorandum, has portrayed my client wrongfully as a supplier to this whole network, which certainly was a large network. As for managerial role, let me in, you have to let me in, Weaver. Weaver answers that. A one-off episode. She was not, nothing that she did, nothing that Karen Johnson did facilitated the offense that my client unfortunately engaged in. I thank you.
Thank you, counsel. Thank you. I don't believe so. Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Mr. LaCar, you were appointed by the court to represent appellant in this matter, and the court thanks you for your assistance.
Case number 22-5121, Optimal Wireless LLC appellant versus Internal Revenue Service et al. Mr. Freeman for the appellant, Ms. Del Sol for the appellees.
Good morning, counsel. Mr. Freeman, please proceed when you're ready.
Thank you, Your Honor. Please, the court. We're here to discuss what this case is about, but I first want to be clear what it is not about. It is not a challenge to the Affordable Care Act. We are asking that the ACA be applied as it was written by the Congress that enacted it. We're not here to upset the apple cart. Our position would actually strengthen the Affordable Care Act. It would insulate it from inevitable challenges that come from characterizing it as a tax, such as challenges as a direct tax. And more acutely, it would insulate it from the consequences of the government's position here that would open it up, at least would open every prior assessment of the employer mandate up to a challenge for a failure to issue a notice of deficiency. So at base, Your Honors, the government's position is fundamentally flawed. Either the exaction is a penalty, in which case the Anti-Injunction Act does not apply, or it is a tax that clearly required a notice of deficiency, in which case the Anti-Injunction Act does not apply.
Couldn't it be a penalty that Congress called a tax? And the question we're asking is, what did Congress call it? I mean, Congress can call a penalty a tax if it wants, and that's the question before us, isn't it?
Your Honor, it is true that in an FIB...
I mean, it's not a constitutional case. We're just trying to interpret a statute. And the question is, what did Congress intend here? It called it a tax 3 times. And, you know, maybe you can make a good argument that it's a penalty, but Congress called it a tax.
You're correct, Your Honor. It did call it a tax, several isolated...
you can call them isolated, but it's part of the statute.
Well, certainly,
That's the only thing we have to go on is the language of the statute. And, you know, every provision of the statute is, I suppose, isolated from every other one. But there are 3 times when it calls it a tax. And so even if I thought you were right, that, look, it really does look like a penalty, Congress called it a tax.
You're correct. And in FIB, the Supreme Court certainly said that generally the best evidence we're going to have is the statutory text.
Right.
I will tell you, we don't ride on a clean slate.
That's for sure.
So in addressing your position, I'll give it kind of the context that I think that helps flesh that out. Our position aligns with the Supreme Court's decision in NFIB. It held there that the individual mandate was not a tax for purposes of the Anti-Injunction Act. It's so held despite the fact that the Joint Committee of Taxation had described it as a tax, that it is located in the Internal Revenue Code, refers to the payor as a taxpayer, requires payment with the taxpayer's tax return is computed on the basis of gross income and exclusively tax concepts, and was not even owed if a tax return was not required to be filed. Our position, though, to your question, Your Honor, is also entirely consistent with, and I would argue compelled by, the text. So the government's position gives talismanic effect to two, arguably three isolated uses of the word tax. The Supreme Court's admonition in NFIB is that the best evidence of congressional intent is the statutory text, not an isolated label.
But that is statutory text. Here, Title 42, Section 1808, 1F2A. It says, you know what it says. It says the Secretary shall establish a separate appeals process for employers who are notified that the employer may be liable for a tax imposed by Section 4980H. That's the statute. It says 4980H is a tax.
Your Honor, I agree that language is in there. I would note two things.
So your argument is that it's isolated. Is that the point?
My argument is in context, it is isolated, Your Honor.
What does that mean?
Well, I
What do you mean
use
by that? You mean?
I use that language because, for one thing, Congress initially and predominantly used the word assessable payment. It used it 7 times throughout, and it also utilized the word penalty. In fact, in F2B of the same statutory provision you're referring to, it then went on to refer to it as penalty. And I would also note that in F2A of the provision you've referred to, the appeals process that is contemplated or directed there by Congress was never, ever established. And
So can we start with assessable payment? So there's 2 alternate formulations. One is assessable payment. There's 3 in the case. One is tax, one is penalty, one is assessable payment. And I think it's one thing to argue that they're all hermetically sealed from one another so that they're mutually exclusive. So it has to be one or the other or the other. That can't possibly be right because 4980H just doesn't work. If you look at it that way, because 4980H uses the term assessable penalty and then uses both the term penalty and tax to describe the assessable penalty. So it just seems to me from the structure of 4980H, we already know that the first term, assessable payment, sorry, I said assessable penalty, I meant to say assessable payment. I think it also does say assessable penalty.
it does.
But let's just take assessable payment. So if we take assessable payment, that could encompass both a tax and a penalty. Just descriptively, it just seems to me to be it's pretty self-evident that an assessable payment includes descriptively a tax, which is assessed and which is paid. And it also could include a penalty, which can be assessed and which can be paid. So the term assessable payment doesn't seem to me to do a lot of work in deciding whether this exaction counts as a tax for purposes of the Anti-Injunction Act, because assessable payment can encompass a tax.
I would disagree, Your Honor, respectfully on several grounds. First,
You disagree that an assessable payment can include a tax?
for certain limited purposes, or if Congress were to clearly state that, I certainly agree that it could.
You just think as a matter of ordinary English that assessable payment, that a tax could be considered an assessable payment?
I don't. Now, I believe in context here, and I believe, and I'll point out one thing at the beginning. I recognize, as I think we probably all do, that this provisions we're dealing with are not a model of clarity. We wouldn't be here if they were. But we don't, again, write on a blank slate, and we have to look at this through a burden framework. Now, the government offers literally a talismanic incantation framework. The word tax was used there, even if the context doesn't indicate that that's what it was intended, that it is a magic word that leads to Anti-Injunction Act application. We offer a burden that is consistent with, and I believe compelled with, by the Arby, Reed Elsevier line of cases.
So can we let's just assume, I have your argument on that.
Yes, Your Honor.
But let's just assume we take that part of the case and put it to the side, that we're not talking about an extra burden to show that something constitutes a tax, because I do think there's a lot of force to the government submission that the burden is to determine whether the statute speaks clearly enough in saying that the particular element at issue is a jurisdictional one. And the Anti-Injunction Act already does that. It shows that it's jurisdictional. It doesn't mean that in determining whether something implicates that jurisdictional consequence, that also has to be clear. I think there's some force to that submission, but let's just, I know you resist that, but let's just put that to one side. The burden just on the text. If we just say that there's no burden that is unduly encumbering one side or the other, just on the text, it just seems to me from the structure of 4980H, it does use the term accessible payment. As a matter of ordinary English, it seems to me a tax can be a form of accessible payment. And the structure of 4980H seems to do that because it says accessible payment throughout, but then it also says sometimes that the particular accessible payment we're talking about is a tax.
So to your point, Your Honor, page 546 of the opinion in NFIB, there the court analyzed, and specifically I'm talking about the two paragraphs where it analyzed section 6201. The Supreme Court there, if you've got a Westlaw print off, it's on the top right-hand corner. Right there, the Supreme Court expressly stated that you can't read the text in isolation. So it was analyzing section 6201, and it expressly rejected the argument that accessible penalties are taxes. I believe that portion of that analysis dismantles the government's entire harmonization argument and goes directly to your point, which is a good one, but I believe the Supreme Court has spoken on it. I would also make two other points on this, Your Honor. The Supreme Court also made...
So that's accessible penalty, not accessible payment.
Correct, but
Okay,
the same logic.
I don't think so. I think there's a separate question about tax and penalty, which needs to be addressed, and we can get to that. But just in terms of accessible payment, why isn't a tax an accessible? It just by every ordinary definition I'm aware of, and it is assessed and it's a payment.
So point two, I think, will address that.
Okay, yeah, please.
Directly on point. So, Your Honor, section 4980H D1, it provides that accessible payments shall be assessed and collected in the same manner as an accessible penalty under subchapter B. Right? As the Supreme Court in NFIB observed expressly, it said the fact that the code requires that accessible penalties should be assessed and collected in the same manner as taxes, quote, makes little sense if accessible penalties are themselves taxes. That critique from the Supreme Court is magnified here, where the code provides that accessible payments should be assessed and collected in the same manner as accessible penalties, which are in turn assessed and collected in the same manner as taxes.
So then is the upshot of your argument, so the Supreme Court wasn't looking at this provision, because it seems to me that something that counters all of that is a provision that actually uses the term tax. It just uses it. Is the upshot of your position then that in the multiple references, I count 4 references to this as a tax, that those are just mistakes?
First, the predicate to the question, Your Honor, the Supreme Court there in that portion of NFIB was interpreting a very closely, almost exactly parallel provision that dealt with how the employer mandate would be assessed and collected. So I think a close reading of those portions of that portion of the statute will show that it is on all fours.
The provision is 6201, or which provision?
Not the provision of 6201, though that one also is relevant. The reason I led with that, but
4980D?
4980 HD1.
Yeah.
Yes, Your Honor, was, and hence the reason I believe the logic carries through in exact parallel here. If I could, your question again, Your Honor, so I can make sure.
So this one says tax is multiple times, 3 times in 4980H itself. It's referred to as a tax. Are those just mistakes?
I believe it's 2 times in 4980H, but,
well, I'm counting the title.
I don't want to quibble about that because your point, I think, is the same either way.
Yeah, just for as a counting purpose, I'm counting the title too.
Okay.
So as the title says tax, non-deductible, and then it says for denial of deduction for the tax.
So I won't go so far to say that it's a mistake, but we have to also ask, I mean, what does assessable penalty mean? That's an unnatural phrase that has never been used before in the Internal Revenue Code. In fact, in the
Assessable payment.
Assessable payment, yes, Your Honor. We've researched that. I believe that is correct. It's not, but it is most certainly an unnatural phrase where I think the default go-to language of the English language would have been tax, or not even thinking about the AIA. Just that would be the natural thing to say there, especially if you thought. So the fact that you deviate from that says something.
But you don't, because you also say tax.
I won't say that, but I won't say it's a mistake, but each provision does have an explanation that does harmonize the provisions. So for example, we've pointed out in our brief that one use of the word tax parallels with Section 275, which denies certain taxes, which by the way, deductibility of certain taxes, which by the way are not all federal taxes. So not all taxes within the meaning of the Anti-Injunction Act. There's an explanation for that provision, but I do go back, and much of my argument does hinge on the fact that I do believe that the Reed Elsevier line of cases does provide the appropriate framework. And I think if you look at the Supreme Court's decision in, I believe it's National Marketing, the opinion by Justice Thomas, he does expressly look to that line of cases as supporting a narrow interpretation of a provision. There it was the Tax Injunction Act, but as you're probably aware, it's interpreted completely in parallel. And so he did look to that as part of the analytical structure for whether or not that applied. And I think you do have to have a framework here. It can't be a magic word, because we all know, and this statute is a great example. We all know how these things get written, and there are a lot of hands in there. And we're ultimately looking at Congress as a body. What was its institutional intention? And we're working against a framework that requires that if you're going to do this extraordinary thing and keep people out of court, you need to speak clearly on it. But also, by the way,
well, assume that that's not right. That this is for the reasons Chief Judge Srinivasan said. Just assume that's not right for a minute. We're just looking at the language of the statute and trying to make the best judgment we can about what this is, right?
yes, sir.
So what's your best argument, setting aside your argument about burden, what's your best argument if you just look at the statute?
Well, if we just look at the statute,
Nothing else, just plain old statute. What did Congress say? And is, an assessable payment can be a tax, and they've said 3 times it's a tax.
so if I accept your premise that it is a tax,
No, don't accept my premise that it's a tax. That's the issue. I mean, I'm happy to have you do it, but I don't think you want to do that.
it's actually not.
Accept my premise that this is just a straightforward question of statutory interpretation. You said it extremely well a minute or two ago. This is a messy statute. There were lots of hands in it. It's not at all. If Congress spoke clearly, we wouldn't be here. But the fact is, we have to do the best we can. And without any additional burdens or anything like that, I want to know what your best argument is that this accessible payment, which they call a tax, is in fact not a tax.
Your Honor, if I said it well, could we just have it read back? So, Your Honor, Section 74.
I only asked the question because you keep going back to your burden.
I do, and,
Yeah.
and I won't this time.
Okay, fine.
It's clear I should
Right.
not. Section 7421 provides that, and there is important precatory language there, except as provided in ellipses 6212A and 6213A. No suit for the purpose of restraining or enjoining shall be brought. 6212 and 6213 both require that if for the government to impose and assess a tax, it must issue a notice of deficiency. So that, for one thing, is a very important statutory provision that indicates that, well, if this is a tax, everything that's been assessed to date was wrong. We've blown up the whole system, everything. If it's not a tax, then we've got the ability, and I maintain it's not. I don't think Congress would have done something. If it's not a tax, well, then we're not barred by the Anti-Injunction Act. I think that is probably, quite honestly, the best argument out there as to why this is not a tax. And it does save the employer mandate.
Was that argument made to the district court?
Your Honor, it is part and parcel of what we've been arguing throughout. So I would argue not voiced or not expressed exactly the way that I did, but we did address literally all these issues and notice of deficiency issues, but it was not expressed in that manner.
So deficiency in 6211A says that it applies to income, estate, and gift taxes imposed by subtitles A and B, and excise taxes imposed by chapters 41, 42, and 43. This obviously, you're not arguing that this is an income, estate, or gift tax. So you're saying it's an estate, it's an excise tax imposed by chapter 41, 42, 43, or 44?
It does appear in chapter 43. That's where it's housed or codified. To be clear, I'm accepting a premise, but I don't actually believe it is a tax. But this is an argument in favor of our proposed interpretation that, well, if this is a tax, as I believe the government myopically argues, the consequence of that, and I don't mean that against counsel, I just mean that this is I believe an unforeseen consequence of that position is that, well, then you are clearly required to issue a notice of deficiency. And that is truly, that will bring on the swell of cases that will challenge this. And that is an issue that will disrupt, if not dismantle, this entire statutory framework.
I think
is that our concern? I mean, Congress makes their bed and they lie in it. That's a policy concern for them, not us.
Agreed. I think that end policy concern, I don't think that can be a stated reason for it, but I do think that is relevant. I mean, it is an accepted canon or modality of textual interpretation to look at, well, what would the consequences of this be? Not for that in and of itself, but in terms of getting inside the head of the institution of Congress and their intention, and would they have intended that? And I don't believe so. And so I do believe that is a relevant consideration.
I think the government might, as I understood the government's argument, they don't accept that provision, the notice of deficiency provision, actually relates to the 4980H action, but we can hear from the government on that. And unless my colleagues have further questions, we'll give you some time for rebuttal.
Can I speak to that particular point very briefly?
Very briefly, you can.
Your Honor, so I believe they're dead wrong on that. Section 301.6211-1A, that's the Treasury regulation that deals with this, specifically deals with taxes under Chapter 43, among others, and specifically deals with situations where there's not a tax return to be filed or filed, and does, by regulation, define deficiency here.
Okay.
And so that would be my position on that.
Okay. Thank you, counsel.
Thank you, Your Honor.
Ms. Del Sol.
Good morning, Your Honor. May it please the court, Ellen Del Sol for the government. We believe the statute here clearly does label this exaction as a tax in 4980H. And as I'll address in a minute, the deficiency procedures under 6211 through 6013 are not applicable here. And no exception to the Anti-Injunction Act was raised below, so that wasn't flushed out below. I'd like to talk first about the statutory text. As Your Honor pointed out, as Srinivasan pointed out, the term assessable payment is used throughout the statute, and that could theoretically, it probably could be a tax because the tax is assessed and paid. But I think section B2, paragraph B2 is particularly enlightening on this because paragraph A and B, E1 oppose the tax and call it an assessable payment. And then in B2, it says the tax imposed by the previous paragraph. And so I think by saying it's the tax imposed by the previous paragraph, Congress very clearly said equated assessable payment with tax. So that instance, I think
You're talking about the language
of B2.
the aggregate amount of tax determined under paragraph 1.
Yes.
That language.
Yeah. So and then paragraph 1 imposes the tax. So when you're looking at those two statutes together, it certainly, or those two paragraphs together, it certainly indicates that the assessable payment is a tax.
Well, paragraph 1 calls it an assessable payment,
That is correct.
and then 2
Two
calls
calls it
that assessable payment
in
a
one,
tax.
and then 2 says the tax imposed by the previous or determined by the previous section. And 2 is the cap on the assessable payment in 1. So I think that linkage of the term tax with an assessable payment is very telling about Congress's label here. And secondly, in C7, which the Fourth Circuit really discounted in the Liberty University case that goes the other way, in C7, it's called a tax, and then Congress specifically points to Section 275, which is the non-deductibility provision for taxes. And in Section 162, which deals with business expenses, Section 162F provides that penalties are not deductible. And I think it doesn't make sense that Congress would have said it's a tax and it's not deductible under 275, which is the provision that deals with deductibility of taxes. If they really meant it was a penalty, they would have then called it a penalty and then pointed to the section that deals.
Well,
with
isn't it a penalty too?
Penalty. I'm sorry, Your Honor.
Isn't it also a penalty?
Well, I think the important thing for the Anti-Injunction Act purposes is whether it is labeled as a tax. And I think these two things are two very clear signs it's labeled as a tax.
But isn't it also labeled a penalty?
The only point at which it's labeled a penalty in the Internal Revenue Code, which is, I think, the relevant statutory provision, most relevant statutory provision for looking at Congress's intent with respect to the Anti-Injunction Act, is in a heading. And Section 7806 of the code specifically says no inferences are to be drawn from headings. And it's also in the section called excise taxes. So if you're going to draw inferences from headings, they really
I
don't
thought it was
help.
also in the text of, it's in the heading in 4980H. Following this through, 4980H C2D,
C2D.
where it says application of employer size to assessable penalties.
I'm sorry. C2D.
Doesn't that applies, right? Because that's in the heading, but it says application of employer size to assessable penalties.
In the heading, yes, but I'm
Right.
sorry, I don't see it in the text.
Then it's in the text of 18081.
Oh, yes, it does say, and we did miss that when we were briefing it. In 1081, it calls it both a tax and a penalty.
Right,
But that is
so-
not in the Internal Revenue Code.
Okay, but that's Congress speaking to this
That
particular.
is Congress speaking, but I think in the first instance in F is talking about the imposition of the tax. The second one is more, is talking about confidentiality provisions, and I think less speaking to the type of the exaction. And I think,
But it says
you know,
is subject to the penalty under section 4980H of Title
that is
26.
true. That is correct, Your Honor.
Pretty direct. I mean,
Yeah, but at the same time, I think to the extent that doesn't really help figuring out what the Internal Revenue Code means because you have two conflicting statements. So to the
well, that's what
extent-
I'm wondering. Are they conflicting? Because it sounds to me like you think the reference to it as a penalty was wrong.
Well, Your Honor, I think there are instances where penalties are treated as taxes, but I
Right.
think NFIB takes it says just because this is a penalty, it's not necessarily treated as a tax, but maybe it could be a penalty and a tax.
Well, that's what I'm wondering is what's your position? Because it seems to me one way to square all this is to say there's assessable payment An assessable payment can be either a tax or a penalty or both. In this situation, Congress referred to this assessable payment in some circumstances as a tax and in some circumstances as a penalty. So it's just both. And there are situations.
To the extent that it's a tax at all, certainly the Anti-Injunction Act applies and provides a very clear jurisdictional bar as this court.
Right. So what I'm asking is the references to this exaction as a penalty. There are references in the U.S. Code to this exaction as a penalty.
That is correct.
Yeah. And so are those mistakes, or are they totally fine because this exaction can be both a tax and a penalty? Seems to me it has to be one or the other. If there's a third alternative.
I don't know that I know the answer to that, because I would have to be able to figure out what Congress meant by that.
But what's the government's theory? Is the government's theory that the references to this exaction as a penalty are just Scrivener's error or mistakes? Or is it that, no, they refer to as a penalty, which is okay because something can be both a penalty and a tax?
I don't think the possibility of something that is both a penalty and a tax for purposes of the Anti-Injunction Act is something that is something that couldn't happen. In subchapter B of Chapter 68, there are a whole group of penalties that are treated as taxes and are taxes for Anti-Injunction Act purposes. So I think that is a viable theory, Your Honor. So I think. And is that
your theory? What would you have us do?
I think that makes sense, Your Honor.
But does it make the most sense? I mean, we have to write an opinion that wrestles with the fact that the statute refers to this as a penalty. It just does.
Yes, it does.
And so then the question is, what do we do with that? We can't ignore it. We can't just pretend like it doesn't exist. So what would the government urge us to do with the references in the code? And I'm counting Title 42 as part of the code, not just the internal code, the U.S. Code, to this 4980H assessable payment as a penalty.
Well, I think you could say that it is a tax and a penalty, but I think for Anti-Injunction Act purposes, the references in the Internal Revenue Code as a tax or what should.
Right, I get that. I get the conclusion because you need that one. But when you say you could say it's both, I'm just asking you, what would you have us say if you controlled it? You don't. We get to make our decision, but we also often ask.
I don't see a problem with saying that, Your Honor. I
know you don't see a problem with it, but I'm sorry to be picky on this, but it actually matters. You're okay with it, but I'm asking, you're the government. I'm just asking the government, what's the government's theory so that we have the benefit of knowing what the government thinks we should do? We should do, not what we could do, what we should do with the fact that the U.S. Code refers to this as a penalty.
Well, I think it certainly could be a penalty for purposes under the HSH provisions, and that would certainly make sense for it to be treated as a penalty for some purposes, but for purposes of the tax code. And
is that what you think we should do? With the references?
I think that's a reasonable thing to do with the reference, Your Honor. But I think the important thing here is that it's I honestly.
Do you think it's also reasonable? I'm sorry to quibble on this, but it actually matters to me. Do you think it's also reasonable to say that the references to it as a penalty were mistakes?
I don't know the answer to that, Your Honor. I'm sorry. I'm not familiar enough with the HHS side of things to be able to answer the question about whether, it could be a penalty under those provisions. And I think for tax code purposes, it is clearly, it has the wording of a tax, which the intent is positive for Anti-Injunction Act purposes. And I see my time's running out.
Would it be fair to say, just to pursue this line of questioning, that you don't know whether it's a mistake or not, but if it's not a mistake, and if Congress meant to say penalty, a penalty can still be a tax?
I think that's true.
That's your position.
Yeah. I think one of the problems that we run into is that in an FIB where it was a penalty for Anti-Injunction Act purposes, Congress declined to read that as moving it into the kinds of penalties that are expressly treated as tax under the Anti-Injunction Act. So I think,
because on that one, it was never referred to as a tax.
Right. But here, the anti-injunction, it is referred to as tax. So, to us, I haven't, as I said, I haven't got a full enough picture of whether in non-tax context that might be a penalty for some reasons. But I think for the.
It's meant to be a friendly question because it's assuming that you win on the conclusion that because the statute refers to it as a tax, it counts as a tax on it for Anti-Injunction Act purposes. Yeah. Then the question becomes, well, okay, but it also refers to it as penalty. Yeah. So what do we do with that?
Yeah. And then I guess the other piece that Optimal's relied on is this no deficiency argument. And I think it's important to recognize that The deficiency procedures only apply to taxes that are reported on a return where you have to report a tax liability. The definition of deficiency in 6211 is a term of art that has that limitation. And there are lots of taxes, including this one, that are not reported on a return. There is a return filed under 6056 that they point to, but that doesn't report the amount of tax. That just reports if the employer is providing health insurance.
I see. So your theory is the notice of deficiency language applies when you have to report it on a return.
That's
it doesn't
correct.
count here.
And the presumption, if you read the regulation as a whole, and it talks about what the taxpayer is deemed to have reported on his return, it assumes there's a return of reporting tax. So the assuming it's zero approach that they argue that the regulation calls for, assuming that they reported zero in their return, if there's no return, is not correct. There has to be a return that reports tax for the deficiency procedures to kick in.
And it's also your position that this argument wasn't raised.
It was not raised below, and no exception to the Anti-Injunction Act was raised below at all, Your Honor.
Make sure there's no further questions.
Thank you very much.
Thank you, counsel.
That's your firm.
Mr. Freeman, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. I will note, I think it's a big thing to come to a conclusion that Congress made a mistake. And so every canon out there of construction would lead me to try to avoid that if possible.
Sure, which equally applies to the fact that they use the term tax.
Yes, granted, which I don't know that helps my position.
Yes,
right.
Take the point. Yeah,
but that's how I would candidly approach it. Doesn't mean that I'm not going to be right, but it does mean I recognize that's not the best thing for my position. But it does seem very highly unlikely to me that Congress meant to signal. And again, we don't write on a blank slate. We write in light of NFIB and the fact that the individual mandate is not a tax for AIA purposes. It seems highly unlikely that Congress meant to signal with these, as I maintain, isolated references to tax, mistake or not, that the mandates here should be treated differently for Anti-Injunction Act purposes. That seems highly unlikely. I would point out that in NFIB, it really is evidence would be the statutory text. And granted, they wrote in a position where the label, at least, was not all over the place like it is here, right? So that makes it definitely the best evidence, and best there could mean that's what we would love to be hanging our hat on. But where it's equivocal, as it is here, it doesn't foreclose. NFIB doesn't in any way foreclose resort to the normal analytical tools to interpret. And I would note the structure of the ACA is important here. So the employer mandate, it falls under Title I, entitled Quality Affordable Health Care for Americans. The final title, Title IX, is titled Revenue Provisions. It enacts multiple express taxes. Sections, for example, 9008, 9009, 9010, impose fees that are, quote, treated as excise taxes and that are specifically and expressly made subject to the Anti-Injunction Act. And on multiple occasions, for example, Section 3000A4, 3007-2, 3008A, Congress expressly removed judicial review, just as it would with the Anti-Injunction Act. I want to note that, Your Honor, with respect to this argument of waiver, the case law on this is clear. That is left primarily to the discretion of the appellate courts, particularly where novel, important, and recurring questions of federal law, particularly those that relate to threshold issues like jurisdiction, that this court routinely takes those up, especially where they are legal issues. And that's really what we have here. This really elaborates on it's two sides of the same exact coin, just a different emphasis for us. But we have a novel, important, recurring issue here related to a threshold question.
Okay.
One last point, Your Honor.
Briefly, please. Yeah.
Ultimately, I think the government here asks the court to rewrite the statute in the name of harmony. But the question is, did Congress, through the text that it actually enacted, did it clearly state an intention that this is jurisdictional? And if it did not, then the statutory text is already in harmony. Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.